Sir, step aside now. Secondary screening. Can you tell me why? I don't need to explain that to you. Actually, you do.
What Officer Lansing didn't know was that the man he was humiliating in front of dozens of travelers would soon be sitting behind a bench in a black robe with the power to dismantle his career. That every dismissive word, every refusal to answer a simple question, every second of this encounter was building a case that would land in federal court. And that by the time this was over, it wouldn't just be his job on the line, it would be a precedent that would force an entire agency to answer for how it treats black travelers in America. Hartsfield-Jackson, Atlanta International Airport. Concourse D, Tuesday morning, late March 2024. The security checkpoint operated at moderate capacity. Business travelers predominated suits, rolling bags, the practiced efficiency of people who fly often enough to know the routine. Judge Marcus Whitfield, 48, moved through the line like everyone else. Federal District Court judge for the Northern District of Georgia, 15 years on the bench. Constitutional law scholar, a man accustomed to being the authority in the room. Here, he was just another passenger. Shoes off, belt removed, laptop extracted from his carry-on and placed in a gray plastic bin. He walked through the metal detector at 9:17 a.m. No alarm. The machine registered nothing. No beep, no flashing light. No indication of metal, contraband, or anything requiring further inspection. But TSA officer Derek Lansing, 34, 6 years with the agency, signaled him to step aside. Whitfield paused, looked back at the detector, then at Lansing. He asked if something had triggered the machine. Random selection, Lansing said. Whitfield glanced at the passengers behind him. 3 men, white, mid-40s, business attire, similar build. They walked through the same detector moments after him. No secondary screening, no diversion. They collected their belongings and continued toward their gates. Whitfield remained where Lansing had directed him. He mentioned his connecting flight 90 minutes until boarding. Lansing didn't acknowledge the information. He was already moving toward Whitfield's carry-on, pulling it from the conveyor belt before it had fully cleared the x-ray machine. This was the beginning. Not dramatic, not loud, just a decision made without explanation, in a space where explanations are rarely demanded. TSA officers operate under broad discretionary authority. The law allows secondary screenings based on objective criteria: equipment alarms, observable behavior, intelligence flags, or genuinely randomized selection protocols. What the law does not permit, what the Constitution explicitly prohibits, is selection based on race. But discretion, by its nature, is difficult to challenge. It happens in seconds, it leaves no paper trail, and it requires proof of intent that rarely exists in writing. Whitfield stood waiting, compliant, calm, doing exactly what the system required of him. It wouldn't matter. Watch how compliance is treated as suspicious. Watch how questions become problems. The pat-down began at 9:19 a.m. Standard procedure. Lansing's hands moved methodically, shoulders, torso, waistband, legs. Whitfield stood with his arms slightly extended, feet apart. He cooperated fully. He asked again about the basis for his selection. Lansing told him he was being uncooperative. Whitfield clarified he was asking a question. That wasn't uncooperative behavior. Lansing didn't respond. Instead, TSA Supervisor Karen Dempsey, 41, 11 years with the agency, approached from the adjacent checkpoint. She positioned herself a few feet away, observing, not intervening. Her presence signaled that Lansing had either flagged this interaction internally or that someone else had noticed it was taking longer than usual. Either way, she chose not to stop it. Lansing moved to Whitfield's bag, unzipped it, began removing items one by one and placing them on the stainless steel inspection table. Legal briefs bound with rubber bands, a laptop in a protective sleeve, a toiletry bag, a prescription medication bottle with Whitfield's name clearly printed on the label. Lansing asked about Whitfield's business in Washington. Whitfield said he preferred not to answer questions unrelated to the screening process. Dempsey stepped closer. She suggested that if he had nothing to hide, answering would expedite things. Whitfield corrected her. That wasn't how this worked, and he was right. TSA officers are authorized to ask questions related to travel plans, but passengers are not legally obligated to answer questions that fall outside the scope of security screening. Refusal to engage in conversation is not evidence of wrongdoing. It is not grounds for extended detention. It is a right, but exercising rights at a security checkpoint often produces the opposite of the intended effect. Dempsey crossed her arms. She looked at Lansing, then back at Whitfield. She said they'd finish this quickly. But they didn't finish quickly. Lansing continued inspecting the bag. He picked up the prescription bottle, read the label, then told Whitfield he'd need to verify it. Whitfield pointed out that the medication was properly labeled with his name, the prescribing physician, and the pharmacy information. There was nothing to verify. Lansing held the bottle anyway. Dempsey signaled to another officer, a younger man whose name tag read Martinez. He came over, stood next to Dempsey, observing. That made 3 TSA personnel now standing around one passenger who had set off no alarms, carried no prohibited items, and displayed no evasive behavior. 15 minutes had passed since Whitfield walked through the metal detector. Airport security operates in a legal gray zone. Courts have recognized that the government's interest in preventing threats to aviation is compelling enough to justify searches that would be unconstitutional in other contexts. But even in airports, constitutional protections don't disappear entirely. Prolonged detention without reasonable suspicion violates the Fourth Amendment. Selective enforcement based on race violates the 14th Amendment. Retaliation for asserting constitutional rights violates both. These are not abstract principles. They are legal standards with consequences. He knew the law. They didn't. And that was about to become a very expensive problem. Sarah Chen, 29, civil rights attorney from a Midtown Atlanta firm, was collecting her belongings, 2 screening lanes over. Laptop, shoes, jacket. She glanced toward the commotion and saw a well-dressed black man standing at an inspection table, surrounded by TSA officers. His belongings were spread across the metal surface. Legal documents, electronics, personal items. She looked at the passengers moving through the adjacent lanes. White travelers, similar age range, similar attire. They passed through without secondary screening, without delay, without scrutiny. She had seen this before, in airports, in courtrooms, in police reports. She knew what it looked like when authority decided someone didn't belong. She pulled her phone from her pocket, didn't raise it conspicuously, just angled it slightly, recording from waist level. She wasn't trying to provoke confrontation. She was documenting, because she'd learned from years of civil rights work that without evidence, incidents like this became contested narratives. And contested narratives rarely held up against institutional denials. Whitfield was still standing at the table. 17 minutes now. 18. His flight boarded in less than an hour. He looked tired, not angry, not agitated, just exhausted by the repetition of having to justify his presence, his belongings, his questions. Lansing picked up the prescription bottle again, asked what it was for. Whitfield said that was a medical question, and he wasn't required to answer it. Lansing claimed he was asking for security purposes. Whitfield told him the label contained all relevant information. Lansing kept holding the bottle. Dempsey motioned to Martinez again. Now there were 4 TSA personnel standing around one carry-on bag. 1 passenger. 0 alarms. 0 contraband. 0 articulable threat. Chen kept her phone angled toward the scene. The recording continued. The longer this went on, the harder it became to justify. And someone was watching. 20 minutes into the screening, Whitfield made a request. He asked to speak with a supervisor above Dempsey's level. Dempsey stiffened slightly. She informed him that she was a supervisor. Whitfield clarified that he understood, and he was now asking for her name and badge number. Lansing moved closer, not threatening in an overt way, just closer. He told Whitfield he needed to calm down. Whitfield's voice remained level. He said he was calm, and he was entitled to identification information from the officers detaining him. Dempsey hesitated. Then she reached into her uniform pocket and produced a business card. She handed it to him without comment. Whitfield took out his phone and photographed the card. Lansing told him he couldn't record. Whitfield corrected him. He wasn't recording the screening process. He was documenting the name of a federal employee who had detained him without clear cause. The distinction mattered. TSA policy prohibits passengers from photographing certain security equipment and screening procedures. It does not prohibit passengers from recording the names and badge numbers of personnel, nor does it prohibit documentation of one's own treatment. Officers frequently blur this distinction, sometimes out of genuine confusion, sometimes to suppress accountability. Dempsey looked at Lansing. Something passed between them. A flicker of doubt, maybe, or recognition that the situation had moved beyond routine. She gave Lansing a subtle signal to wrap things up, but instead of closing the inspection, Lansing opened the carry-on bag again. He pulled out a manila folder, began flipping through the papers inside. Whitfield informed him that those were legal documents, privileged attorney-client materials. Lansing said he wasn't reading them, just inspecting them. Whitfield asked what he was inspecting them for. Lansing didn't answer. Whitfield exhaled slowly. He didn't raise his voice, didn't use profanity, didn't make any gesture that could later be characterized as threatening or uncooperative. He simply asked the question that any person in his position had the legal right to ask. Am I being detained, or am I free to go? The question hung in the air. Dempsey didn't answer immediately. Lansing stared at the documents in his hands. He was doing everything right, and it didn't matter. Remember that. Dempsey still hadn't answered when Lansing noticed something. A business card, partially visible beneath the manila folder on the inspection table. The text was small but legible. Honorable Marcus Whitfield, United States District Court, Northern District of Georgia. Lansing's expression changed, not dramatically, just a slight shift in the eyes. A pause. He glanced at Dempsey. She leaned forward slightly and saw it too. The air in the checkpoint changed. Dempsey's tone shifted when she spoke again. She told Whitfield they were just finishing up. Whitfield observed that they'd been finishing up for 20 minutes. No apology was offered. No acknowledgement of error. Dempsey simply nodded at Lansing, who began returning items to the carry-on bag quickly now, with less care than he'd used removing them. Laptop placed roughly into its sleeve, documents shoved back into the folder, toiletries dropped into the main compartment. Whitfield watched. He didn't help, didn't reach for his belongings, just stood with his arms at his sides, waiting. When Lansing zipped the bag and held it out, Whitfield took it. He opened it briefly to verify the contents. Everything was there, though disorganized. He slung the bag over his shoulder, looked at Dempsey, then at Lansing. He told them they would be hearing from him. Then he walked toward his gate. Neither officer responded. They didn't call after him, didn't offer explanation or apology. They simply watched him go, standing in the checkpoint where dozens of other passengers continued moving through without incident. They didn't say sorry. They didn't explain. They just let him go, as if none of it had happened. But it had, and he wasn't letting it go. 2 days later, Judge Marcus Whitfield filed a formal complaint with the TSA, Office of Civil Rights and Liberties. The complaint detailed the March 26th incident, identified the officers involved, and requested specific records, screening logs for that checkpoint on that date, personnel training files for Lansing and Dempsey, and demographic data on secondary screenings conducted in Concourse D over the preceding 6 months. The TSA's response was slow. Weeks passed, then a month, then 2. When documents finally arrived in late June, they came heavily redacted. Black bars covered entire paragraphs. Sections were missing. Explanations were withheld under claims of security sensitivity and ongoing personnel matters. But what remained told a story. The screening log showed that Whitfield had been detained for 28 minutes. The average duration of secondary screenings at that checkpoint, according to TSA's own data, ranged from 6 to 8 minutes. Whitfield's screening had triggered no alarms. No prohibited items were found. No prior intelligence existed regarding his travel patterns. No supervisor had documented any articulable basis for the extended detention. Whitfield retained Monica Reeves, a civil rights attorney with a regional practice focused on 4th and 14th Amendment violations. Reeves filed a Freedom of Information Act request targeting broader data. She wanted to know whether the treatment Whitfield received was an isolated incident or part of a pattern. The FOIA response took 4 months. When it arrived, it included anonymized screening data from Hartsfield-Jackson's Concourse D checkpoint, covering January through June 2024. The numbers were clear. Black male travelers passing through that checkpoint were subjected to secondary screening at a rate 3.2 times higher than white male travelers in the same age demographic. Traveling during the same time windows, with similar baggage and travel patterns. The disparity wasn't marginal, it was structural. Federal agencies are required by law to respond to civil rights complaints and FOIA requests in a timely and transparent manner. Delays, excessive redactions, and procedural obstruction often indicate something worse than bureaucratic inefficiency. They indicate an institutional attempt to obscure patterns that can't survive scrutiny. The paperwork told a story they didn't want told. The case moved to federal court in October 2024. Whitfield, represented by Monica Reeves, filed suit under Bivens versus 6 unknown named agents, the legal framework that allows individuals to sue federal officers for constitutional violations. Discovery began, depositions were scheduled. Derek Lansing sat across from Reeves in a conference room at the TSA's regional counsel office. Court reporter present. Video camera recording. Everything on the record. Reeves asked why he had selected Whitfield for secondary screening. Lansing said it was random selection. Reeves asked if there had been an alarm. Lansing said no. She asked if contraband had been detected. No. She asked if prior intelligence existed regarding the passenger. No. She asked what made the selection random. Lansing shifted in his seat. He said there were behavioral indicators. Reeves asked him to describe them. Lansing said he couldn't describe them specifically. It was based on training, instinct, pattern recognition developed over years of screening thousands of passengers. Reeves noted that instinct wasn't a legal standard. She asked if he could point to any specific observable behavior that justified the stop. He couldn't. Karen Dempsey's deposition was conducted 3 days later in the same conference room. She acknowledged that the detention had lasted longer than average. She admitted that Lansing hadn't followed the de-escalation protocols outlined in TSA training materials. But she defended the officers' actions as falling within their discretionary authority. Reeves asked what that discretion permitted. Dempsey said officers had discretion to ensure safety. Reeves asked whether Judge Whitfield had posed a safety threat. Dempsey paused, then said they didn't know who he was at the time. Reeves leaned forward slightly. She said they shouldn't have needed to. The TSA brought in Dr. Raymond Kepler, a former screening supervisor turned consultant, to testify about operational realities, high-pressure environment, thousands of passengers daily, split-second decisions, the necessity of deference to frontline personnel who operate in conditions most people don't understand. But under cross-examination, even Kepler admitted there was no TSA policy that supported a 28-minute detention without documented articulable suspicion. No training manual that authorized prolonged questioning of a passenger who had set off no alarms and carried no prohibited items. Qualified immunity exists to protect government officials acting in good faith within the boundaries of clearly established law. But when the constitutional violation is obvious, when race operates as the determinant factor and selective enforcement immunity collapses, the law on this point has been clear since the 1,960 seconds. Every answer made it worse. Every justification fell apart under the weight of its own contradictions. The trial began in February 2025. Judge Whitfield recused himself, naturally. The case was assigned to Judge Angela Torres, a Carter appointee with a reputation for meticulousness and a low tolerance for procedural gamesmanship. Monica Reeves presented her case methodically. She introduced the screening data, the video footage Sarah Chen had recorded on her phone, statistical analysis prepared by an expert witness showing the pattern of disproportionate stops, testimony from passengers who had passed through the same checkpoint on the same day without secondary screening. Chen took the stand on the third day of trial. She described what she had observed, the prolonged detention, the contrast between Whitfield's treatment and that of similarly situated white travelers. The way Whitfield had remained calm and compliant while being treated as though his presence itself was suspicious. The defense argued operational necessity, officer discretion, the absence of explicit racial animus. They presented witnesses who testified about the challenges of airport security work and the importance of allowing frontline officers latitude to make judgment calls. Judge Torres interrupted during closing arguments from the defense. She said discretion was not a shield for discrimination. She said the question before the court wasn't whether the officers were working in a difficult environment. The question was whether their actions in this specific instance violated clearly established constitutional rights. The cross-examination of Derek Lansing had been damaging. He contradicted himself multiple times, claimed he had followed protocol, then admitted under questioning that he hadn't documented the basis for the stop, said the selection was random, then referenced behavioral indicators he couldn't identify or describe. By the time he left the stand, his credibility was gone. In her closing argument, Reeves didn't raise her voice, didn't perform outrage. She simply laid out the facts in chronological order and connected them to the law. Judge Whitfield was stopped because he is black. He was detained for 28 minutes because he asked questions officers didn't want to answer. He was subjected to treatment that white passengers in identical circumstances did not experience. That is not security, that is not discretion, that is a violation of the 4th Amendment prohibition against unreasonable seizure and the 14th Amendment guarantee of equal protection under law. The jury deliberated for 4 hours. They returned a verdict in favor of Marcus Whitfield on all counts. Compensatory damages, $150,000. Punitive damages, $75,000. Injunctive relief requiring TSA to implement mandatory bias training, revise secondary screening protocols for Hartsfield-Jackson Airport, and establish an independent oversight mechanism for reviewing complaints of discriminatory enforcement. Judge Torres read the verdict aloud in open court. Lansing stared at the table in front of him. Dempsey's face remained neutral, unreadable. Whitfield sat beside his attorney. He didn't smile, didn't nod in satisfaction. He just listened. The money wasn't the point. It never is. The point was this: even here, even at the airport checkpoint, the Constitution still applies. But winning in court doesn't undo what happened. It doesn't erase the 28 minutes. 6 months after the verdict, the Department of Homeland Security Office of Inspector General opened a broader investigation into TSA screening practices at Hartsfield-Jackson Atlanta International Airport. Other complaints emerged. Similar stories. Black travelers, Latino travelers, passengers of Middle Eastern descent, all subjected to longer detentions, more intrusive questioning, different treatment than white passengers moving through the same checkpoints at the same times. Derek Lansing was reassigned in September 2025, not terminated, not disciplined beyond a written reprimand placed in his personnel file. He was moved to an administrative role reviewing baggage screening reports at a regional office outside Tampa. Karen Dempsey received a written reprimand. It noted procedural failures and inadequate supervision. It went into her file. She retained her position as checkpoint supervisor. The TSA issued a public statement: commitment to fairness, dedication to protecting civil rights, new training initiatives under development. All the institutional language agencies deploy when litigation forces acknowledgement of systemic problems. But independent auditors who reviewed the new training materials found them inadequate. Vague guidance. No concrete protocols for identifying and preventing implicit bias. No accountability mechanisms for officers who deviate from policy. The institutional defense remained consistent. Officers work in high-pressure environments. They face genuine threats. They must make rapid decisions with incomplete information. But Whitfield's screening wasn't rapid. It was prolonged, methodical, unjustified by any objective measure. And that distinction mattered. Security agencies routinely invoke operational secrecy to avoid accountability. National security considerations, sensitive procedures that cannot be disclosed, information that might compromise screening effectiveness. Courts have become increasingly skeptical of these claims, particularly when civil liberties are at stake and when the alleged security justification collapses under factual scrutiny. The system acknowledged the violation. It paid damages. It promised reform. But it didn't fundamentally change. Officers kept their jobs. Policies were revised on paper, not in practice. And travelers continued passing through checkpoints, wondering whether today would be the day they'd be stopped for reasons they'd never be told. The system bent. It didn't break. And that's the part that lingers. Go back to the moment. The 26th of March 2024, 9:17 a.m., Hartsfield-Jackson, Atlanta International Airport, Concourse D. Marcus Whitfield walks through a metal detector. Shoes off. Belt removed. Laptop in a bin. No alarm sounds. But Derek Lansing signals him aside anyway. Secondary screening. Whitfield asks why. This is how it happens. not with slurs, not with overt malice, not with visible hatred or explicit intent to harm. It happens with assumptions, with discretion that operates without oversight, with the quiet, persistent belief that some people require more scrutiny than others, and that intuition, that gut feeling, that sense of something being not quite right is sufficient justification. It happens in airports, in traffic stops, in schools, in hospitals, in courtrooms, in every space where authority decides, consciously or not, that certain people don't quite belong. After the trial, Marcus Whitfield spoke briefly to reporters outside the federal courthouse. He didn't claim victory, didn't celebrate. He said something simple. He didn't file the lawsuit because he was a judge. He filed it because he was a black man who shouldn't have to be a judge to be treated with dignity and fairness at an airport checkpoint. The camera didn't save him. Sarah Chen's video helped, but it wasn't determinative. The law degree didn't save him. What saved him was knowledge of his rights, access to legal representation, and the financial resources to pursue a case that took nearly 2 years to resolve. Most people don't have those resources. Most people endure the detention. They miss their flights. They absorb the humiliation. They tell themselves it's not worth the fight. They move on because they don't have a choice. And the system depends on that. For every Marcus Whitfield who makes it to a courtroom, there are hundreds who don't, who can't, who won't, whose stories remain undocumented, unlitigated, unresolved. The question that remains, the one no verdict can answer, is this: what happens to them? Should it take a federal lawsuit to get basic respect at a security checkpoint? Should it take a court order to change discriminatory practices? Who pays the real cost when discretion becomes discrimination, and who should bear the responsibility for fixing it?